I pray for your lordship's kind leave to mention one uncontested probate application, my lord, for correction of my lord's order, my on 2nd September 2025.
To be mentioned.
My lord, may it appear as to be mentioned?
Yes, yes, to be mentioned.
Read.
On fourth schedule audio, your lordship passed an order directing me to file inventory account delayed at condon delayed. But department is ignoring this order, but they are not receiving this order.
No.
As there is no time mention is there.
No. Okay, let it appear as to be mentioned.
Department not accepting the order as there is no mention time mentioned. That is. Right.
Yes, call the to be mentioned.
Mention.
And the applicant, my lord.
Yes.
That kindly see.
Anyway.
Yes, order, my lord. To necessary papers to me, but not.
Let me see the order, previous order. Let me note.
I am carrying specific order in these documents, my lord.
Yes, this order was issued on 4th September. Yes.
Not necessary papers.
No question, yes.
No papers, no documents have been handed to me today, my lord. I am carrying specific order, my lord.
No. What is the present position? You have communicated this order.
Yes, my lord.
Yes. Now, what is the problem?
Only problem, specific order, specific documents I am carrying.
No. What documents you want?
Judgment and degree with commissioner report and with sketch.
Then you come with an application, necessary application. What documents you want? Because you see, as per the report.
I filed an application for certified copy, my lord.
No. Application before this court. Any application have you filed?
Yes, my lord.
What is that?
For certified copy, my lord. To the register. 24th April 2025.
So let there be a direction to issue that certified copy.
Yes, my lord.
Yes, record an order. The matter is put up for necessary clarification. In terms of order dated 4th September 2025, there was a direction that section officer, there was a direction that necessary copy be issued upon the learned advocate who has applied for the same under supervision of the court officers by making photocopy from outside the court premises. All necessary rules and formalities be complied with. Stop. Learned advocate submits that till today the copy is not issued. Thus, it is clarified that the certified copy of
Judgment and degree. With commissioner report.
With commissioner's report and
with sketch.
With sketch map be issued upon the learned advocate within 1 week after vacation.
Full vacation, I am very urgent, my lord.
Okay. Within 2 weeks. Within 2 weeks.
Yes.
ওটা দরকার নেই ওটা
Item number 3.
It may please your lordship, I am for the plaintiff. My lord, the parties have settled the dispute, my lord. The defendant is here, my lord. Now the instructions are to withdraw the suit, my lord. This is the instruction that has been given to my learned advocate on record, my lord, from the plaintiff.
You are for the plaintiff.
Yes, my lord, for the plaintiff, there are two defendants, my lord. The instructions are now to withdraw the suit. It has been settled between the parties. On the last occasion, my lord has been pleased to retain a copy of the terms of settlement, my lord. And we have want to simplicity to withdraw the suit, my lord.
Yes, record an order. Learned advocate for the plaintiff is present. Learned advocate for the plaintiff files the instruction issued by the plaintiff for withdrawing the instant suit. Learned advocate for the plaintiff submits that the disputes between the parties have been settled and terms of settlement has already been filed.
Yes.
In the facts and circumstances, this suit stands dismissed for non-prosecution. Interim order, if any, stands vacated. Let the written instruction filed be kept with the record.
Obliged, my lord. Obliged.
Item number 4.
Lord, in this matter, I am appearing on behalf of the plaintiff, my lord. In this matter, my lord, on last occasion, on 26th of August 2025, my lord was pleased to pass an order. And under instruction of our client, we have preferred an recalling application before my lord, which is presently in the.
This is which application?
This is in the suit itself, my lord. CS 356
Which order was passed?
Yes, my lord. 26th August 2025. In the suit itself, there was a affidavit. On that basis, the order was passed, my lord.
No, question is 26th August 2025.
Yes, my lord.
This order was passed.
Yes, my lord. Under
So-
instruction of our client, we have filed a recalling application, which is going to be listed on 18th of September, my lord.
Question is, where is the scope of recalling this application? Upon considering the submissions, I have passed some directions.
My
There,
lord,
there is no scope for any recalling.
my lord,
Upon considering the submissions,
yes, my lord.
upon considering the facts, I have passed this order. So
we will try to satisfy, my lord, on the
Please.
Please,
There
my
is
lord.
no ground for recalling.
Kindly, my lord, we list it on the 18th of September, my lord. I am humbly praying for the listing the matter to 18th of September, my
Okay,
lord.
let it appear.
Yes, my lord.
18th.
18th of September.
Let this matter appear on
18th of September.
9/2025.
My lord, deeply obliged.
Item number 5,
Correct.
Your Lordship.
Date is to be fixed, my lord,
I appear for the plaintiff. On the last occasion, it was submitted that talks of settlement was going on. We had, my lord, approached them for settlement, but no response has come from them. So, my lord, we'll
Lord,
proceed
talk
with
to
the
the
suits.
client.
If it settles, it's
Correct.
fine, but we'll proceed with the suit.
Yes, let this suit appear after vacation.
Yeah.
In the meantime, let this matter go for mediation. If mediation proceedings fail, this suit will be taken up. Yes, record an order. Learned advocates for the parties are present. It is submitted by the learned advocates that although talks for settlement was started, but the matter is not yet settled. Stop. In the facts and circumstances, this court is of the view that this matter may be sent to mediation for settlement, for the purpose of settlement. Thus, I refer the matter to mediation. Stop. Learned mediator to be appointed in this case is requested to see that the matter is settled amicably between the parties in accordance with law. Fix. 7/11/2025
On
for
my lord,
report.
perhaps in between mediation may not happen due to puja vacation,
No, 7/11. I'm keeping this matter
7/11.
in the month of November.
Or maybe
I'm
in the
grateful.
third week of November, my lord, subject to. my lord,
Okay, let this matter appear on
Not
12
third week, my lord, second week. I think it is
12,
both
12,
accept-
12/11/2025
12/11.
for report of the mediator.
I'm
Let-
grateful, your lordship.
Let
I'm
this
grateful.
matter appear on 12/11/2025 under the same heading.
Deeply obliged.
I'm grateful, your lordship.
And for the petitioner, my lord. The non-contentious probate that was.
Yes. Hence, this application stands allowed. Probate of the last will and testament of the deceased be granted to the petitioner as executor with effect throughout the state of West Bengal. Let probate be issued upon compliance of all necessary formalities.
Grateful lordship.
Disposed. Yes, now call the fixed matter. Specially fixed matter. কত কবে আসার কথা? তাহলে ইয়েটা কল করুন, আমি অর্ডার করে দিচ্ছি।
Fixed matter at 10:30 AM, at number 1.
Yes, record and order. This matter is due to appear on 12/11/2025 at 3 PM. And it is appearing by mistake today. Stop. Let this matter appear on the date fixed.
For argument at number 7.
Wait, your lordship.
I beg to appear for the.
My lord, I am appearing for the plaintiff with Mr. Ghoshal.
But one submission, my lord. In
No,
the
item 7.
Item 7.
You are for the plaintiff.
Yes, my lord.
I'm for the defendant state. It's for arguments today. If the plaintiff completes the argument, my lord, I'll only humbly pray that a time may be given to us, my lord, to respond on any day next week, my lord.
Have you
Any day.
started your arguments in this matter?
Not yet, my lord. To start the argument.
Start the argument.
Yes, my lord. Yes, my lord.
Yes.
May it please your
Dekh,
lordship.
records টা দেখি।
My lord, suit is a suit of 1990. It is. Yeah, I think. My lord, gist of the matter is this, my lord. The plaintiff is a contractor. In pursuance of a notice inviting tender issued by the defendant, plaintiff participated in the tender. At the time of dropping his tender, as was required, plaintiff deposited a sum of ₹20,000 by your National Savings Certificate. His tender having been accepted, he was directed to start the work to be had at Exhibit B from 18th of May 1987 and to complete the work by 7th of June 1988.
Yes, which paragraph?
Paragraph. My lord, paragraph 2.
Yes.
By memo number so and so, dated 16th of May 1987. Herein before mentioned, the plaintiff aforesaid tender was acknowledged and accepted by the subordinate engineer for and on behalf of the defendant. The said memo was in the nature of the work order issued by the subordinate engineer. The rates was accepted at 4.95% above the estimated cost, estimated amount at rupees 15 lakhs an hour, put to the tender by the defendant. It was thereby provided that the work is to be commenced on 18th of May and ended and completed by 17th of November 1998, that is within a period of 18 months. That is the Exhibit B. That is the Exhibit B. A copy of the said memo number so and so, dated 16th of May, is hereinafter hereto annexed and marked as annexure A to the, and the plaintiff gives leave to refer to the same as a part of the plea.
Yes.
Dear Lordship, kindly take up the Exhibit B.
Exhibit,
B.
exhibit,
Dated 16th May 1987.
that is page. Let me see. Huh? Page 1. Yes, this is the notice inviting tender.
No, this is the work order.
Okay, copy of the tender executed on 18th of June 1987.
16th of May 1987.
16th of May 1987. So, okay, I have before me is this copy of the notice inviting tender, then copy of the tender
Yes,
executed on 18th June.
Yes, madam, this one.
Oh, this is the
Last two columns from right side.
supplementary. Yes, that
Date
is
of commencement. of the
Exhibit
work.
B.
Yes, madam, Exhibit B.
Yes.
Date of commencement of the work, 18th of May. Date of completion of the work, 17th of June 1988.
Yes.
And a plaintiff having taken up the work by his letter dated 14th of June 1987.
This is 16th of May 1987. Thereafter,
Yes, madam. About a month thereafter, work was started with effect from 18th of May 1987, and this letter was written on 24th of June 1987, roughly about 2 months.
24th of
Roughly about
June
1 month.
1987. That is page
Exhibit D.
Exhibit V.
D for the lead.
D.
Handwritten document.
D.
Exhibit H. Exhibit D.
So probably it would be after 3rd June 1987.
Page 55, main judge's brief of document.
Page 52 probably.
No.
Page 55, main judge's brief of
55. 24th June 1987.
Yes, ma'am. Yes, ma'am. This is for your kind consideration that there is a mud road which are the only transport road to carry the building materials for the
Yes.
work of PHA at Taipat. Local panchayat are now developing the road from the proposed hospital to Shimuntola Moor and the rest of the road from Shimutala moved to Chaipat Bridge are the irrigation bed. So the local porches are unable to develop the road. So this is in this rainy season, it is not possible to carry the material, and the progress of the work will be stopped till the rainy season will be over. We shall bear here huge loss in the ideal time. If you allow to develop the road, you by yes, the same will be going on throughout the year. This for your kind information. Also kindly acknowledge the acknowledgement at the bottom of the page. That was received by the department on 24th of June 1987. Then your lordship kindly come to Exhibit L. We had at page 68 of the lordship's brief. Your lordship got it?
Main judge's brief of document, page 60.
Dated 15th of February 1988. Has your lordship got it?
Yes, yes.
To the executive engineer through proportional subject first supplementary bill for construction of PH at Chitpur. We are working Chaipat Health Center. There is a damaged bridge more than 50 meters span approximately between the canal
More to site.
between the Chaipat Moor to site. From the bridge, the site is about 1,350 meters. We carried all the building materials by head load and this. In normal case, 20% cost of the total cost will be charged for remote place with the schedule. But in our case, we are deprived, unfortunately, the 20% extra charge. As a result, we are facing extreme trouble to carry out the building materials with bearing huge loss. We are not in the position that if our supplementary bill will not be passed, then the work will be stuck up because the penalty money will not be higher than the actual loss. We have completed already work valued 4 lakhs approximately on anticipation that supplementary bill will be passed. So we submit the first supplementary bill for your sympathetic consideration. So my lord, before I part with this document, there are 2 parts. Here I am lodging my supplementary bill or supplementary bill with a proposal. In the event you are unable to agree with me, then I will but to stop the work. I have but to stop the work. Lordship kindly keep in mind. There is a provision in this letter, unless you agree to consider my first supplementary bill, we will be compelled under the circumstances not to proceed with the work. Now, my lord, next document is Exhibit L to be had at page 69. Yes. Lordship got it. We hereby submit first supplementary tender 6 copies for carriage of material by head load from Chaipat to so and so work for your kind approval. Your immediate steps in this regard will be highly appreciated. Enclose 6 copies of the supplementary bill. Then your lordship would find it was received by the assistant engineer, and the process is that all letters are to be addressed to the executive. In case the letters are addressed to the executive engineer, it is to be forwarded to the assistant engineer. Then your lordship would find the annexed supplementary bill at pages 70, 71, etc. Has your lordship got it? Then your lordship kindly come to Exhibit L, M for business, at page 72.
Yes.
A handwritten letter or document by the assistant engineer to the executive engineer. Enclosed 6 copies of supplementary bill received from the contractor working in the site. This for his information and take disposal, please. The site is separated by a canal over which 2 bridges,
Damaged bridges.
exist. This is a fact that the construction carried
Contractor carried the
contractor
building
carried
material
the building materials
by
by
head.
headload up to the site. My lord, here there is a recommendation by the assistant engineer certifying that I am carrying the working materials by headload. Next document is our second supplementary bill. Then your lordship kindly come to exhibit N. N for Nagpur at page 74.
That is 21,988.
Yes, my lord. Sending back herewith the original supplementary submitted by the concerned contractor with instruction from superintendent engineer for his submission in total form with proper recommendation from this end. At the customary petition, I am reading the letter again.
So a copy of this letter was served upon you?
No,
So
I got it and it has been exhibited.
no, you got it from where?
Assistant engineer.
No, you collected. No, this copy was.
That may not. I submitted the comprehensive.
No, this copy was a. No, this copy is addressed to the assistant engineer. You see, this letter was addressed to the assistant engineer, but was a copy forwarded to you?
Kindly wait for a moment. Kindly come to exhibit Q.
Page
84. You are requested to resubmit the original supplementary in total form at the early date as directed by the executive engineer so and so. So, my lord, this was the position till the work was being carried out within the first extended time. Then lordship kindly come to page 82, that is exhibit S.
Yes.
This is a certificate. In my favor, we have completed 80% of the work. Certified that structural work of Chaipat PSH are complete and the cost constitutes about 80% of the total work. My lord, next your lordship kindly come to the comprehensive supplementary tender to be held in exhibit T.
Page 83.
Page.
No.
83.
No, এটা সাপ্লিমেন্টারি মনে হচ্ছে।
Financial, under the heading financial implication for supplementary tender.
No, which page?
That
That is supplementary brief for this original brief.
83.
83, yes, 83.
83 তো না, এটা কত? No.
Your lordship got it?
না।
No, 85 or not. Financial implication for supplementary tender.
দাঁড়ান, পাওয়া যায়নি এখনো।
A typed document of 1 page.
এটাই দেখছি তো।
এখানে আছে। এখানে exhibit E.
Your Lordship, page 2 of supplementary judge's brief.
I guess.
Yes, page 2, financial implication.
Yes, kindly come to the signatories. Signatory is assistant engineer on 3rd of February 1982. 89. Financial implication for supplementary tender, the original tender, so and so, so and so. Then name of the word, name of the agency, tender number, estimated amount, tender amount, total amount for the work, 8th column, anticipated value of the work, including the value of supplementary tender. What was 15 lakhs and all, now by reason of the supplementary tender, it would be increased to 19 lakhs and all. Lordship got it?
Yes.
Then your Lordship kindly come to exhibit U. U for union, supplementary brief, page 3. Tarapoda Bhomi, that is the plaintiff, written by assistant engineer, subject supplementary tender, please letter dated 15th of February 1989. With reference to your letter under reference, the letter above, this is to inform you that supplementary tender in total form as submitted by you has already been forwarded to the executive engineer for favor of his disposal. So, my lord, I was being assured from time to time that my supplementary tender is in the process. They are considering my supplementary tender. My lord, before I part with this document, Lordship will kindly find right from the second month of the execution of the work as against a stipulated period of 16th month, I was intimating that about the HON'BLE position. And they are writing me till up to 28th of February 1989 that they are in the process of considering my prayer. Your Lordship kindly come to page 7 of the supplementary document. Exhibit is exhibit marked as W. Memo is dated 19th of July 1989, written by executive engineer to Tarapur, that is the plaintiff. In view of the comments made by the assistant engineer.
That is page?
Page 7 of supplementary.
Page 7, exhibit W, dated 19th of July 1989. Lordship got it?
Yes.
To Tarabodo Bhumi, subject first supplementary tender for construction of Chaipat Public Health Center in the district of Midnapur. In view of the comments made by the then assistant engineer Tomluk and sub-assistant engineer Tomluk in charge of supervision of the above work, that the condition of unserviceable bridge was same when the tender for the above work was invited. In an inquiry made from this end, the same comments with your The same comment with your application was forwarded to the superintendent engineer, South Circle. But superintendent engineer, South Circle has informed that condition of the breach being known to the contractor must have considered these aspects of approach to the site while quoting to the rate.
Yes.
My lord, also kindly visualize the situation. If the condition was same, and if it was known to me right from the date of dropping the tender, equally that was known to them, they ought not have entertained my supplementary. They ought not have assured me that your supplementary is under consideration. Kindly back to the document. Exhibit N, page 79, 74. Proceed, buddy. Page 74, Exhibit N. Sending back herewith in original supplementary submitted by the concerned contractor with instruction from superintendent engineer for resubmission in total form with proper recommendation from this end. All I am on, at that point of time, I was being assured and I was required to resubmit comprehensive supplementary bill. I submitted initially first supplementary bill for about 35,000. Then I submitted another supplementary bill. In the meantime, they sent me the instruction to resubmit the comprehensive supplementary bill, which is worked out at about 3 lakhs and odd. That is, initial work was valued at 15 lakhs and odd. Kindly come to Exhibit T, that is additional brief at page 2. Supplementary. Page 2. Proceed, Gordon.
Yes.
Kindly concentrate on item number 7. Total amount of work 15,83,202. Anticipated value of the work, including the value of the supplementary tender, 19,69,000.
That means the value of the supplementary tender was taken into consideration by these authorities.
Sorry.
The value of the
And I
supplementary.
was being assured that my supplementary tender is under consideration. And on that basis, I proceeded the work. At the end of the work, at the end of the period, after the expiry of the first stipulated period, that is, Lordship will recall, the contractual period ended on 18th of August 1988. That is to be held at Exhibit B. First document I relied upon.
Yes, Exhibit B.
Date of commencement 18th of May and date of completion কত দেওয়া আমি পড়তে পারছি না এইটা
17,488 or 17,588.
17,588. After this, I am being told that your supplementary will not be accepted. Then, my lord, in answer to this, I wrote to them that unless you agree to my supplementary tender, it would not be possible for me to continue.
Where is that letter?
Yes, my lord, I have come. In spite of that, unilaterally, they extended the time. Kindly, very interesting thing. Kindly come to Exhibit X, page 9. Dated 20th July 1989.
This is letter addressed to you
Yes, my lord.
by the executive engineer. Where is your letter?
I did not apply.
Question is that
Oh,
you
this-
said that
this is a-
if you don't pay, honor the supplementary bills, it will not be possible. Where is that letter?
That is my exhibit CC,
Page
page 15.
page 15.
Page 15. Before that, I need to place this
Okay.
extension because
So
I
this was your
No, no, no,
17.
also kindly consider their unilateral extension.
Where is this? So page 9 is the extension.
Yes, madam. Let me place it. Extension of time of the aforesaid work is hereby granted by the undersigned up to 30th of September 1989. As such, he is requested to expedite the progress after the reserved so that the work may be completed within this period granted. It may also be noted that no further extension of time will be granted except in special circumstances. Now, the next sentence, this is in handwriting. Extension is granted in the interest of the public work without accepting the grounds shown in his letter. This is the unilateral action.
Now, without accepting the grounds shown in his letter.
And kindly mark this, in a typed document, this sentence is written by hand.
Anyway, that is an afterthought.
Yes, madam.
Thereafter, handwritten and signed.
During the original stipulated time, I was being assured, even I was told, that your supplementary has been forwarded to the appropriate authority. I have been told to resubmit the supplementary tender as is desired by the superintendent engineer. That is in Exhibit N, with instruction from the superintendent engineer for resubmission in total form with proper recommendation from his end. My lord, what is the recommendation?
Who is to recommend? Superintending engineer?
No. Assistant engineer was to recommend.
Yes.
The final accepting authority was the superintendent engineer.
Okay, no. Question is this approval granting authority. I think that is the executive engineer.
Here is the
No, first of all, it has to be recommended.
Yes, ma'am.
Yes.
My lord, my bill for selection order had been recommended initially by the assistant engineer as in Exhibit T, that is page 2.
Page 2, yes.
They come to last two sentences of this document. This site is separated by a canal over which a damaged bridge exists. This is the fact that the contractor carried the building material by headload to the site. The bridge was found damaged at the time of carriage of the material.
So this is the recommendation, page 2.
This is the comprehensive form.
No, comprehensive form, yes, by the assistant engineer.
Comprehensive form. Then what about the first recommendation? Respecting my first supplementary, would your lordship kindly come to exhibit N to be had at page 72.
Yes.
Lordship got it. Kindly note that this is a document, this is a memo dated 24th of February 1988. That is within the stipulated time. Last sentence. This is a fact that contractor carried the building materials by headload to the work site. Which is repeated in the document in Exhibit T.
That is page
2
Of supplementary.
of supplementary.
This is the letter and this is the bill.
Yes. The site is separated by a canal over which damage exists. This is a fact that the contractor carried the building material by headload to the site. Well, this is how I am drawing your attention to the stand of the defendant at that point of time. Now, what is my stand? Lordship kindly come to Exhibit V at page 4.
Core of the original.
Supplementary.
Supplementary.
27th March 89 letter.
Yes.
Tarapada Bhumik, that is plaintiff is writing to the executive. Subject payment of the supplementary for construction of so and so. Before starting the above mentioned work, we already informed in our letter dated 3rd of June 1987 for the damages over Tondeshwar Canal near Chaipara, which needs repair immediately for carrying the building materials to the construction site. Otherwise, the total cost will be increased. But no response on your side indicated that your silent consent to increase the cost. We submitted our first supplementary tender on 15th of February when 1/4 of the total work was done, with giving our comments that either you pass the supplementary or penalize us because penalty money will be lesser than the actual loss. In the meantime, we submitted our second supplementary on auto on 7th of March 1988. On 30th of May 1988,
20th,
superintendent engineer visited the site. After the above incident, assistant engineer Tomluk subdivision showed a letter to me that executive engineer Midnapu, memo number so and so, dated so and so, where such comments are sending here is the original supplementary by the concerned contractor with instruction from the superintendent engineer for his submission in total form. We submitted the total supplementary, and that is equivalent to 30% of the tendered value, approximately 3,37 lakhs. In the meantime, 1 year has passed and the work is nearly complete. We are suffering extremely for financial stringencies, etc. We are unable to make payment of the wages of the workers dues of the suppliers. As a result, the progress of the work has been reduced, stuck up position. So we are requesting you to make arrangement for payment of at least 50% of the supplementary work will be done. Then, my lord, we received this letter, Exhibit W, that it was known to me and it is in the meantime rejected by the superintendent. Then your lordship is seen, in spite of our application, no application, extension has been granted on the ground of public interest, subject to correction by your lordship. In a commercial contract, there cannot be the scope of alleging public interest. Kindly appreciate this. Then your lordship kindly come to.
No, but you see, the state authority has a duty to look after the public interest, where public at large are affected.
True. I did
It's not that totally it has to be devoid of public
I
interest.
did not disagree. I raised a point. Please pay me the supplementary bill, which you assured me during the execution of the work. Then your lordship kindly come to next exhibit, that is exhibit Y, to be had at page 10.
Of the supplementary.
Yes.
My lord would recall that in one of the letter we are told that the executive engineer requested the contractor to resubmit the bill as desired by the superintendent.
So let us consider this letter 30/11/1989.
Now, my lord, kindly come to 30/11/89. Tarapada Bhumi regarding supplementary, your letter dated 27th of October 1989. In inviting a reference to the subject cited above, I am to inform you your supplementary claim for carriage of materials by headload has been turned down by the superintendent engineer South Circle as per terms and conditions of the contract. Well, before I part in this first sentence, would your lordship kindly consider as to whether there was any necessity to give me an opportunity to move in the matter? There having been so many assurances after the expiry of the original tender period, and in spite of my not applying for extension of time, superintendent engineer, as if the superintendent engineer has disagreed. I was not given an opportunity to explain the situation. Had I had the opportunity, I would have pointed out, well, sir, you did this.
So whether the letter of the superintending engineer goes to show that he has disagreed.
That is nothing. There is nothing. Excepting this first sentence, in inviting a reference to the subject cited above, I am to inform you that this supplementary claim for carriage of the material by headload has been turned down to the superintendent.
That means there was no recommendation from his side, superintending engineer's side.
No, recommendation was there. Acceptance had not been done by the superintendent.
No, recommending authority and approving authority are two different. Okay. Recommending authority is the superintending engineer.
Executive is the recommending authority.
Executive engineer is the recommending authority.
And the SC is the accepting.
And superintending engineer is the
accepting authority.
Yes, accepting or approving authority.
Approving authority. And thankful to my learned friend. Second sentence. As per terms of the contract, you are responsible to carry the material to the work site at your own cost and responsibility for execution of completed item of the work. Before submitting the tender, you have signed the explicit declaration to the effect that you have inspected the site of the work. Kindly mark this expression, site of the work. Whether this expression site of the work would be inclusive of a broken bridge at a distance of 1 mile and
1350 meters.
1800 meters.
Now, question is, site is
Site is
site is
something
site is a place,
where the construction is to be
took
done.
place, and that
And
is,
get
no,
to
and
your lordship.
construction materials is to be carried from one end of the particular point to the other end, which is connected by a bridge.
Yes, madam.
That means that means from one end to the other end, it is connected by a bridge.
Bridge.
In the middle there is some river or something like that.
Yes, canal.
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 So from the two sides, on one side of the canal, the building materials are dropped or collected,
Yes, madam.
and from
And
to
then-
the other side,
By head load we carried it. We crossed the bridge.
what
by
is the
head-
distance between one side to the other side?
Ultimately, by your lordship's court's order, there is an inspection, and on that inspection, it has been found that the distance is 1 kilometer and 800 meters. I'll come to this. My lord, second sentence, as per terms of the contract, you are responsible.
Okay, when did you accept this tender? Date of acceptance and date of representation that about the condition of the bridge?
Yes, my lord,
No, date of acceptance of the tender.
date of acceptance, no, date of commencement is there,
No, date of commencement is when?
18th of May 1987.
Okay,
that is
18th of May 1987, the work was commenced.
Commenced. And
Okay.
it was to be completed by 17th of May 1988.
And regarding your grievance, your representation that the bridge is damaged and you have to carry the materials by head. What is that? Which date that letter was addressed?
15th of February 1988. Exhibit L.
That means after a period of
After a period of about 7 months.
7 months.
7 months.
So till that date, you carried.
No, before that we wrote to
That
them.
date, may I just, the date of acceptance was 14th April 1987.
14th April 1987 was the date of acceptance.
Yes.
Date of commencement is
16th of May 1987.
Yes.
16th of May 1987. Okay. And thereafter, the work commenced.
First, on 24th of June 1987.
Where is that?
That is Exhibit D,
Exhibit D.
page 55.
Because the work commenced and thereafter you wrote. That is Exhibit D.
D,
That is page.
page 55.
Yes.
Second paragraph.
24th June. That is after a period of 1 month.
Yes, ma'am.
After a period of 1 month.
1 month. My lord, to be frank and candid to your lordship, my lord, I pointed out about the road, not about the unserviceable bridge. I prayed that if you grant me some sum, it will be developed.
No, question is, you see, two things. You see, road means what? That bridge itself is the road. That is the connecting
Yes, ma'am.
road from one end of the canal
Consists
to
of
the.
bridge. It
So-
includes the bridge.
Yes, road means, you see, from one point to the other point. If the road is dilapidated, vehicles can go.
Yes, ma'am.
But if the bridge is,
Your lordship will get it from their own document. I am coming to it.
no, that is what I'm asking. That after a
Uh,
period of 1 month, you made this grievance and
Intimated that-
representation.
intimated that, and in the month of February, that is after expiry of about 7 months, I raised my supplementary bill. which
What
was
is this? What is this letter about?
Supplementary bill, first supplementary is 15th of February, exhibit.
No, 24th June 1987. This is your first letter.
Yes, madam.
This has nothing to do with the bill.
No. Yeah, we raised the first bill on 15th of February 1988. Madam, to assist my submission, I submit to your lordship a list of dates. Lordship, kindly come to 15th of February, that is exhibit L, page 69. We hereby submit first supplementary tender, 6 copies for carriage of material by head load. Got it?
No, this is after a long episode, but let us see the developments from your, that is 24th June 1988. Okay. This is your difficulty. This is your predicament. That is 24th June 1987.
24th June 1987. Yes.
Because work commenced.
Yes.
Thereafter, you face difficulty.
And
So
whether it was followed.
So let us see. So this is what you can. Mud Road.
May I submit to your lordship to take up?
Yes. What was the letter? Any reply to this 24th June?
No. At least it has not been exhibited.
This is?
There is no letter which has been exhibited. We did not receive any letter.
Yes.
Lordship, kindly come to exhibit L, page 69.
So you expressed your desire to develop the road.
That is the first letter. And 15th of February 1988 is exhibit L.
Yes.
Page 89. We hereby submit first supplementary tender for carriage of the material by head load to the working site for your kind approval. Your immediate steps in this regard would be highly appreciated. Then, your lordship, this was received by the assistant engineer. The next page is the supplementary bill for about 34 lakhs. 34,000.
Yes.
Lordship, now can we again come to exhibit M. As against our supplementary bill dated 15th of February, we are assistant engineer is writing on 24th of February 1988 within a short period. To the executive engineer, subject supplementary tender. Enclosed 6 copies of supplementary tender received from the contractor working in the site for his information and taking disposal please. The site is separated by a canal over which damage beaches exist. This is a fact that the contractor carried the building materials by head load to the work site. Here is the total admission. Here is a total admission. My lord, in fact, they are not raising any objection as to the quantification of the amount. Rather, my claim stands certified. The entire 3,34,000 stands certified by the department. Then, my lord, I was told in Exhibit N, page 74, we submit the total supplementary tender with proper recommendation from the state government. That is page 79.
Page 79.
Exhibit N.
Yes. Page 79.
Page 74. Also got it.
Yes.
Standing back here with the origin supplementary submitted by the concerned contractor with instruction from superintendent engineer for resubmission in total form with proper recommendation from his end.
So where is that rep? So upon consider there are two recommendations.
I
That
understand.
is page, that is the first page probably. So one is the letter, the other is in a comprehensive form.
Uh,
Two recommendations are probably there.
yes, my lord. Next page,
That is
that is Exhibit Q, page 84.
page 84.
I was directed to resubmit by the assistant engineer. Exhibit
Yes,
Q.
84, yes.
To Tarapodo, you are requested to resubmit the original supplementary in total form.
No,
And
that
now
means he has submitted. Okay.
as directed by the executive engineer so and so.
Okay, now that is there.
Then, my lord,
Another question is this.
then, my lord,
The recommendation part. Where is that recommendation
yes,
part?
my lord. Recommendation is Exhibit T,
That is page.
page 2,
Of supplementary.
supplementary.
The supplementary 10 guy.
Page 2. Yes. Page 2 by the assistant engineer.
Yes, my lord. Kindly concentrate your attention at item number 7.
And page 3. Oh, page 3.
Total amount of the work 15 lakhs and odd. Anticipated value of the work including the value of the supplementary tender 19 lakhs and odd. That is exactly what is my comprehensive supplementary tender. Then, my lord, kindly come to the last sentence. The site is separated by a canal over which a damaged ditch exists. This is a fact that the contractor carried the building material by headload to the site. The bridge was found damaged at the time of carriage of the material. Now we are being told that as if the assistant engineer in their internal meeting stated that condition was same.
Where is that? Let us see the rejection order.
Yes, my lord. That I have. That is the exhibit W. Page 7.
July 89.
19th of July 1989.
Page 6. Page
7.
Page 7.
Supplementary.
In view of the comments made by then assistant engineer Tom Luke and service engineer Tom Luke,
Yes. Yes.
in view of the comments made by then assistant engineer Tom Luke and service engineer Tom Luke in charge of the supervision of the above work, that the condition of the unserviceable bridge, kindly mark this word, was same when the tender for the above work was invited. In an inquiry made from the end. I am laying stress.
So one is the observation of the assistant engineer, the other is the observation of the superintending engineer.
In an inquiry made, unfortunately, I was not invited to participate. This is an internal and query having no access to me. Then my Lord Lordship kindly come to page 10, that is exhibit 1.
Yes.
I read first portion, I am reading it again. Has your Lordship got it?
Yes.
In inviting a reference to the subject cited above, I am to inform you that supplementary claim for carriage of material by headload has been turned down by the superintendent engineer, South Circle, as per terms of the contract. As per terms of the contract, you are responsible to carry the material to the work site at your own cost and responsibility for execution of completed item of work. And before submitting the tender, you have signed the explicit declaration to the effect that you have inspected the site of the work and you have made yourself fully acquainted with the local condition in and around the site of the work. And after considering all aspects, you have quoted your rate to carry out and complete the work. The condition of the bridge was therefore known to you, and you must have considered this aspect of approach to the site before quoting your rate. In view of the above facts and circumstances, supplementary tender cannot be entertained by the department. In this connection, I am to state further as follows. In reply to the points raised in your letter under reference, notice inviting tender is only an abridged form where only the nature of the work, estimated cost are mentioned. Details of the site condition are not mentioned. In the notice inviting tender, details of the terms and conditions and other particulars were embodied in the tender document which were purchased by you before dropping the tender. And after going through the same documents and after being acquainted with the site condition, you have quoted your rate to carry out and complete the work to the satisfaction of the department. Department has therefore no intention to suppress and actually had not suppressed any material fact to you before entering into the contract. Each in question has not been changed during the extension of the time, and it has remained the same all along since invitation of the tender. Moreover, it is seen from record available in the office that the bridge and the road leading to the site is motorable during a considerable period of the work, and you should have planned to carry the material by motor vehicles accordingly, and then you must consider that while quoting your rate in the tender at the cost of reputation. Moreover, it is seen from record available in the office that the bridge and the road leading to the site is movable during a considerable period of the year. As against the work order of June, it is exactly my case. With the onset of the monsoon, the road became unserviceable. Next paragraph. Superintendent engineer is the accepting authority concerned of the concerned supplementary tender, and as such, any instruction of the executive engineer to contractor to submit his supplementary claim in total form does not mean acceptance of the claim. My lord, I am afraid such could be a stand of a department. Kindly back to this letter that I have been directed by the superintendent engineer to request you to resubmit. The next sentence. Clause D. Assistant engineer is not aware of the terms and conditions of the tender, which lies in division office, and he might have forwarded your claim with this comment. The claim was therefore forwarded with the commencement of the executive engineer to the superintendent engineer, the accepting authority, who have ultimately rejected the claim. Recommended.
Rejecting authority or approving authority is the executive engineer.
Yes, ma'am.
Only the recommending authority may be the superintending
No,
engineer.
accepting authority is superintendent engineer.
No. Approving authority or rejecting authority is the executive engineer.
Yes.
The approving authority, ultimately it will be either approved or rejected.
Or
by the AC.
rejected.
Yes, by
By
the
the
AC.
same authority.
That is the AC.
Superintendent engineer.
AC, superintendent engineer. Yes, the hierarchy is this: the AC lies at the top, and below him is the executive, and below him is the sub-assistant engineer.
Okay, executive engineer is the
the middle-
ultimate authority to approve or to reject.
No, AC, superintendent engineer is
Okay,
higher,
superintending engineer
higher in rank
is
than
the
engineer.
ultimate authority
Yes.
to accept or to reject.
Yes,
Okay, and the recommending authority is
is the executive,
executive.
not the assistant. Assistant is-
Executive. Executive.
Comes under the executive
Yes.
engineer.
Yes, ma'am.
Yes.
He also recommended.
That means assistant engineer at best can forward it to his
Which is
immediate
correct.
superior.
That is executive.
That is executive. Thereafter, the matter can be placed before the superintending engineer.
Yes. Not you have seen. Assistant engineer recommended. Superintendent engineer told me that your bill has been forwarded to the, I'm sorry, executive engineer told me that your bill has been forwarded to the superintendent engineer, who has directed that instead of piecemeal supplementary bill, you got to give for comprehensive bill. Kindly back to exhibit 10.
No, that means your bill was supported with your representation, reasons.
Huh.
That means your supplementary bill was backed by reasons and or your representation, as you may say. Supplementary bill supported by you was backed by, from your side, was backed by certain grounds for why you are submitting the supplementary bills.
Because I could not cross the
So when the bills went, whether your representation, that is your grievance and the grounds, were before the authorities were not.
proof. I gave the ground, and my first supplementary bill was back to me with a request, instead of filing first supplementary or second supplementary, you file comprehensive bill for the total work. Kindly back to exhibit 10,
Page 74.
page 74.
Yes.
Lordship got it. Sending back here the original supplementary submitted with the concerned contractor with the instruction from superintendent engineer for resubmission in total form with proper recommendation from his end. My lord, if the conditional
Okay, that means these were forwarded to return to assistant engineer with the direction to
engineer, first supplementary bill was returned with a direction that the contractor be directed to submit the comprehensive bill as instructed by the superintendent engineer.
for resubmission in total form with
This
proper.
is in answer to my first supplementary, only for 34,000.
Yes, so this is okay with regard to for resubmission in total form in a comprehensive with proper recommendation from his end.
Yes. Total, what was the first supplementary bill? It was 34,000 and odd. And what is the comprehensive bill? Comprehensive bill is 3,34,000. Then, my lord, in exhibit Q, page 84, I was directed to resubmit the comprehensive bill. Not got it.
Yes.
Then I submitted, and upon receipt of my bill, the assistant engineer in exhibit T certified that the site is separated as exhibit T,
Page 2.
page 2 of the additional.
Yes.
Before that, Lordship kindly come to item number 7 of this document. Total amount of the work accepted to be involved.
That means, see, upon considering the hierarchy, the assistant engineer may recommend to the executive engineer, who may thereafter recommend to the superintending engineer.
Yes, my lord.
And it is the superintending engineer who is to either approve or reject.
Reject. Subject to one thing. What is the ground? Ground is as if I was aware of this site condition right from the date of my submission of the tender. Lordship, kindly
So
consider.
far the terms and conditions of the contract provides that in case the work could not be completed and there is extension of time,
It is.
because we cannot go beyond the contract.
I will come to you. My lord, what is the ultimate ground for rejecting?
Yes, you are aware about the condition of bridge.
Condition of site.
Which includes the condition of bridge.
It includes the condition of bridge. My lord, I might have to join issue. Site means the place of execution. Site cannot include the road through which the materials are to be passed at a distance of about 1.8 kilometers. Kindly appreciate the distance. 1.8 kilometer cannot be in anybody's conception that it would be inclusive of the word site. Site is a defined term in the contract. I will come to. At the moment I am submitting, if my statement is correct, that the distance is 1.8 kilometer, whether this distance is also within the definition of the work site. Within the definition of this work site. Lordship has seen the explanation. Executive engineer is saying that
That means, you see, the labor of the employees, that is the labors of the contractor, had to carry the materials.
no, through additional contractor
No.
for carriage purpose.
No, for carrying the materials, another contractor was engaged.
No.
Your grievance was this: the materials, there was no motorable road.
So we have to carry by our labor, by hiring labor, different type of labor. For construction of a building, one type of labor is employed.
For carrying the materials.
That is a different type of labor. Would your lordship kindly back to page 10, exhibit Y.
Yes.
subclause C.
Yes, para 10.
Yes,
No, page 10, clause.
subclause
Clause C.
No,
of
of
the
the,
supplementary.
yes, page 10. Yes, clause C.
The superintendent engineer is the accepting authority of the concerned supplementary tender, and as such, any instruction of the executive engineer to the contractor to resubmit his supplementary claim in total form does not mean acceptance. My lord, I could have understood it, provided expression as in exhibit N is same. Kindly come to exhibit N.
Yes.
With instruction from the executive engineer to for resubmission in total form with proper recommendation from his end. Now he says that I advised you, executive engineer advised you. That is not the context of exhibit N. Subclause. Kindly make a comparison between the expression used in subclause C of exhibit Y. And as such, an instruction of the executive engineer to the contractor to resubmit his supplementary claim in total form does not mean acceptance.
Yes, that is the ground of rejection.
Then what was the original letter?
Yes.
With instruction from the superintendent engineer. That is the exhibit N.
Anyway, continue on the next day, next Friday.
Next Friday.
Conclude on the next date.
Yes, you will take that.
I will give it.
Yes, record an order. Learned advocate for the plaintiff submits but could not conclude the submission. Let this matter appear on 19/9/2025.
Your Lordship kindly consider the position
Yes,
that this matter as at a particular time.
19/9/2025
At
At-
first,
at 11:30 a.m.
deeply obliged to your Lordship.
पाठात कोण पाठात
Part of the
Okay, on that day I shall make it Parthat.
deeply obliged to your Lordship.
Number 8.
I am for petitioner being short passed over.
Okay, not today.
Item number 9.
Lordship, item number 8.
8.
For the plaintiff, my lord.
Today is fixed for special officer's report.
Yes, my lord. It could not have been completed as of yet. My lord kindly places it after the vacation, my lord. In the meantime.
Yes, record an order. Learned advocate for the plaintiff is present. Today is fixed for filing report of the special officer. However, as the report could not be made ready, the time to submit the report stands extended till 29/10/2025.
Yeah.
Let this matter appear on 29/10/2025.
I'm extremely grateful, my lord.
My lord, this is item number 9. My lord, there is no dispute in partition suit under CS 41 of
No,
1989.
none of the parties are appearing.
Yes, my lord. They are contending the suit. Only myself have submitted all documents, evidence regarding partition.
My lord,
9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9. 9.
You are for 4A and 4B.
Yes, my lord, yes.
So
My
come
lord,
ready on the next day. The
yes,
matter has to be heard out.
my lord, I am plaintiff number one. Except me, nobody can give any documents, any evidence.
Whatever it is, in the presence of the advocate, the matter has to be heard out. Why you
My lord, that will be too difficult for me, my lord. They are
nobody is
trying to keep
appearing.
it pending, my lord. If they are not attending, plaintiff number one can proceed. Kindly allow me to proceed, my lord. There is no dispute. My lord, kindly record it.
When can you come ready? When can your senior come ready?
They have got no documents, my lord. That will be last chance, my lord.
Yes, record an order.
My lord, kindly allow me to say something.
In
My
the
lord.
absence of the other side, yes, let me see the report. Just
Honorable court has passed and direction on me to proceed in appear in person, my lord. That will suffice the purpose for continuing this hearing, my lord. With the
no, all learned advocates have to be heard. If they do not make themselves present on the next day, I shall see.
My lord, I want to say one more thing, my lord, that is very, very important. Order dated 9 January 2025,
Yes.
which clarifies that it is stands at witness action of plaintiff number.
Let me see the report of the registrar, please.
I need a copy of that also. We are suffering, my lord. All these advocates are involved in secret attempt to sell the property. That's why they are absconding. At least my submission be recorded, my lord. My submission be recorded, my lord. It is extreme case of fraudulent activities by court-appointed advocates. I am shocked. Preliminary decree has been passed. I think it is in the report.
Now the partition commissioner has to be appointed to partition the property by meets and bounds.
By meets and bounds, and my lord, the gist is that, my lord, 10 owners, first thing, my lord, kindly refer genealogical table in plaint, which confirms that we are first family of Calcutta and before British period, my lord.
Question is, you see, the preliminary decree which is passed, that has to be followed.
That has to be followed, but it has been set aside, my lord. There is correct order, my lord.
Preliminary decree set aside?
Yes, my lord.
Where is that order? Please show.
Yes. This
You
is,
see that order, whether preliminary decree is set aside or not? Please see that order. Give the learned advocate one copy.
Here it is written. My lord, I am reading out. It appears that another prayer was made in the application under Order 9, Rule 13 of the court for setting aside the order dated 3rd February 1999, by which the defense of the present appellant was set aside. And Commissioner of Partition was appointed in order dated 19th February 1999.
The preliminary decree was set aside. That is the question.
Yes.
Where is that? Please show me.
This double bench order, my lord. Clearly stated, my lord. Preliminary degrees, this order comes with two important notches, my lord. First thing, advocates are appearing in without okalatnama. That is an offense. It harms the dignity of Calcutta High Court, my lord. In our case, I object, my lord, that no advocate without Okalatnama should appear, my lord. Kindly do not allow. Only advocate Dev Chandra has got proper Okalatnama. No advocate should come before your lordship without Okalatnama. It harms dignity of Calcutta High Court, my lord.
Please, let me go through the order.
Sorry, my lord. Page number 8, last paragraph. Application under 9 rule 13 is allowed. আমি হোয়াটসঅ্যাপ করে দেবো। হ্যাঁ, ওকে আসতে বলবেন, ওই একমাত্র হ্যাঁ, ওর ওকালতনামা আছে, ও কেন আসবে না? উচিত না, কারণ এটা প্রপার্টি রিলেটেড ম্যাটার। আমি আমার প্রপার্টি শেয়ার আছে, আমি কাউকে চিনি না। My lord, this is page number 8, last paragraph, my lord. Application under rule 9, trial judge is set aside. The suit is restored. My lord, page number 8 says, since we have restored the suit, clearly written, my lord. And last line said the suit is restored. And page number 9 says, in view of the order, the appointment of Commissioner of Partition by the learned trial judge by virtue of order dated 19 February 1999 is set aside. So Commissioner of Partition is also discharged. So we are looking for fresh appointment of Commissioner of Partition who will continue as receiver with me. Because court has already given me all major responsibilities, my lord.
Yes, where were you so long?
You
You don't appear when the matter is taken up.
Court number 69.
All these problems arise.
Court number 6. I
Yeah.
apologize.
Interposition, we are in the dark. The court is in the dark about what is the present position.
Present position is, my lord, witness action as per.
Yes, now the question is, as per the division bench order, the preliminary decree was set aside. Thereafter, the matter came before Justice Sanjeev Banerjee, probably. And thereafter, what was the order passed? Yes. No. I believe the preliminary decree was passed thereafter. Yes.
Thereafter.
Just may I just indicate what is the factual background of this? This is a suit for partition of various of a property at Park Bazaar. Initially, we deposed, a preliminary decree was passed. That was challenged in the 90s. That was set aside. Matter went before the appeal court, also set aside. Order affirmed. Matter was
preliminary decree was set aside.
Preliminary decree was set aside.
Yes.
Matter went up before the appeal court also upheld that setting aside order. Matter again came up before the single bench.
Yes.
Her father was one of the original defendants of the suit. After the matter was before came up before the single bench, her father expired. She got substituted as a legal heir. In 2013, probably, she took out an application to get herself transposed as a plaintiff. That was allowed. She deposed. Now, what her contention at right now is that she takes a stand that the properties are partible. But her father's stand in the written statement was that this is a Devotto property, there cannot be any partition.
Sorry to intervene, my lord.
Please,
My
sir.
father's signature was forged.
Her also contention, now she takes up this stand that the written statement, which was filed in 1989 by her father, she alleges that the signature which is appearing in the written statement of her father is a false signature, not of the signature of her father. That's her contention. These are the two contentions. Matter has traveled from one single bench to another single bench for what Milo can see from the orders that has been released, and it has been assigned from time to time. Now, when the matter came up before Honorable Justice Rai Chattopadhyay, we made a submission that the records of the suit, that's a setting aside of the preliminary degree, order of the appeal court, are required to be produced and seen. I tell your lordship why. Because in that preliminary, when that preliminary degree was passed in 1990s, then my lord, we have tendered the original Solenama, the Orponnama, original Orponnama before the honorable court. The original has been tendered in every. So once we again go before in the box, we need that original Orponnama to tender it again for marking it.
Now the question is, after the preliminary decree is set aside, the preliminary decree is not yet passed.
Not yet passed.
So the preliminary decree has to be passed upon hearing the parties in accordance with law.
Yeah, she has deposed.
Whatever it is, in accordance with law, the preliminary decree has to be passed.
Yes.
Now it would be better on the next day, further proceedings are to take place. You come with a list of dates and with the compilations of the orders passed, so that further directions can be given.
We
come with a list of dates with a note and the compilation, so that necessary direction can be passed. I'm giving this matter after vacation.
Grateful.
After vacation, that will be too much troublesome for us.
Prior
And
to
let
vacation,
there
there
be
is
a
no
direction.
scope.
My lord,
Also,
this is
let there
specially
be.
assigned matter. I am
Maybe.
entire matter
And
before
also,
Honorable Chief Justice.
we need.
And
We would be
Honorable Chief
requiring
Justice
this vacation.
Okay, time is short. Okay, so this matter has to be taken up after vacation.
Yes, we would be requiring this time to prepare the
then
list of
our
dates and the
position,
notes.
my lord, I am just explaining the matter. My lord, this is a picture. My lord, this is rectangular space, our premises, and from 1/6 part, that is extreme southeast corner, That is 1/6 part of.
Yeah, is there any receiver appointed?
Yes, receiver has,
This is
receiver is,
making
receiver has.
Yes, yes, yes.
My learned friend is.
What is the present position there?
It is
There are.
not working. He is not listening. to
Please
us, my
let
lord.
me
Well,
listen to.
there are outsiders in our position, my lord.
Very well.
That's
There,
why
there are
partition,
there
my
are
lord.
3 tenants, long tenants.
No tenants, my lord.
Old tenant, 1976.
My lord, they
Hassan
are
was there.
forcefully and by illegally occupying these places,
Please
my lord.
let me.
My lord,
Please let me listen to the receiver.
they are
Okay.
telling lies, my lord. So I
Very well.
want
Very well. The court is here to decide who is telling lies. Now, my lord, I serve notice to the tenant to produce their documents. They have produced documents, all the rent receipt, that and the. I request them, according to 1997 West Bengal Premises Tenancy Act, will be effective from 2001. You are entitled to stay 5 years. And Senior Citizens Act, also Miller's combined notice, I serve. I have filed report. Okay, I am granting you one more opportunity. During vacation, hold a meeting with the parties and their learned advocates. Each month, my lord. Yes. Each month, I hold meeting. Yes. But 2 or 3 members are coming. No, nobody is coming. I'm making it clear. I'm making it clear that they will appear, attend your meeting, give the grievances. Submit now, kindly, Milord. Yes. Now, Milord, without due process of law, I cannot. No. That is his hard. Court is not directing. She is directing me, requesting me to evict them. How could I?
our position is broken.
Yes.
Plaintiff number 2B2D.
Let me civil order appearing for.
Making our praise, my lord.
Let me civil order.
Our
Lordship's order.
persons are coming through my stairs.
I cannot.
Already ordered, my lord.
Very well.
And all these advocates are involved in murdering us, my lord.
Yes, you are appearing for. You are appearing for.
2A series.
Learned
My lord,
advocate
may order
or defendant number.
Ravikrishan Kapoor passed an order, my lord.
Please. Two series. Learned advocate.
My lord, all these are
number
involved in murdering us, my lord.
Learned receiver.
My lord, kindly let
appointed in this matter.
Kindly let.
Yes, you are appearing for. Learned
Everybody is
advocate
taking
number.
money from us, my lord, illegally from our bank account, my lord.
Please let me record the order. Please take your seat.
My lord, what
Don't
will
create
happen?
chaos inside the court.
Court is giving it.
Please, I'm telling you, please, once again, please take your seat.
We want receiver to be discharged.
Please, I'm once again requesting you, please. Learned advocate for defendant number 4A. 4B, learned advocate.
Their Opalatnama is not correct.
Yes, you are for. Yes, Mr. Datto.
2 series.
2C.
2 series.
2 series. Learned receiver present. The plaintiff number, your plaintiff number?
1.
1, who is appearing in person, is also present.
Lord, my name should be in appearance column.
Yes. So, hard learned advocates and the plaintiff who is appearing in person. Learned advocates are requested to come with a list of dates and the compilations of orders which are passed in this matter to pass further orders. As there is a grievance by the
Plaintiff number 1.
Plaintiff that the property is occupied by unauthorized persons.
In possession of lady resident owners.
Learned receiver shall hold a meeting with the parties as well as their learned advocates and submit a report on the next date fixed.
Otherwise, my lord.
Let this matter appear on 6.
Our life is in danger, my lord.
Let this matter appear on 7/11/2025 under the same heading. In the event learned receiver is prevented from discharging the function, he may take necessary help from the police authority.
My lord, another direction be passed upon police officer to record unauthorized occupants and dilapidated conditions in my possession, my lord. I am plaintiff number 1. I
given-
confirm.
I've given it in my order. I've recorded that in my order. Please go through the order.
Yes, my lord. Kindly refer genealogical table to confirm our legacy
Very well. Come on
of
the next
Niyogi
page.
family, and my lord cost title, my lord, and also confirm refer that defendant number 3 died intestate bachelor
That's how.
and has been expunged from cost title. That order is vibrant. So any will in that name without probate, without registration should be held cancelled and suspicious, and proper penal action should be levied on them, my lord.
That's all.
Yes, my lord, and all suspicious activities of receiver Shamul Kumar Mukherjee regarding 18th May 2022 order should be taken up.
Very well. Thank you.
Yes, my lord.
My lord,
I'm for the plaintiff. my
I'm
lord.
for the defendant, my lord. There are 3 applications, my lord, on board.
Our
One, my
appearance
lord, for
supported.
the first application is, my lord, for my application for my lord, filing of the written statement, extension of time to file the written statement. The
So
second is
affidavits
his application-
are complete.
My lord, in GA1, we don't have any objection. Let them file their written
No,
statement.
I have not pressed an application as yet.
Okay, this order 7, rule 11 is pending.
No, there's no order. sir.
The second application is his.
Order 7, rule 10.
No, my section 10 is pending.
Oh, section 10 application.
That's why, my lord, may I, my lord, file my lord, opposition to my lord his application, which is GA2, and my lord, my reply in GA3.
My lord, I'm
Lord,
filing.
all these applications, my lord, has to be heard out. Lordship will kindly keep it sometime after the vacation, my lord. Only
Yes,
one, my lord.
learned
My lord, I'm
advocates for
filing my
the
opposition to the.
parties are
He has not-
present.
And my lord, he has not filed any
Uh,
reply to my opposition. That may be
the
recorded.
applications GA1 of 2025, GA2 of 2025, and GA3 of 2025 is taken up for consideration. Let affidavit in opposition filed with
Filed my affidavit in opposition in GA2.
2 of
I filed.
2025, which is filed in court, be kept with the record, and
And my lord, my reply in GA3.
and reply, if any, be filed on or before 26.
No, they're filing today. my lord.
Reply,
My lord, reply, my lord, we will not use. my
I'm
lord.
granting you the opportunity. If you don't want to file, well and good. Be filed on or before 26/9/2025.
And my lord, I filed.
And
reply
with
in
regard to GA3,
I filed my affidavit in reply today.
I'm filing my opposition.
and let the affidavit in opposition and affidavit in reply filed in GA3 of 2025 be kept with the record. আগেরটা যেটা বললাম GA2 of 2025. GA1, I think.
GA1, they have not preferred any opposition, my lord.
Okay. Let this matter appear on
Anytime.
24/10 on the reopening date.
Very well. 24th, my lord, can it be?
Reopening date.
Subject to lordship
Subject to
convenience, my lord,
lordship
can it be on 27th?
No, it
27th.
has to be on Fridays. It has to be
Okay,
on Fridays.
31/10.
My lord, kindly allow me to mention, my lord.
একটু শেষ করে নি একটু দাঁড়ান আপনি
Yes, so
31/10.
So come ready if you don't want to file, well and good, it will be taken up.
Wait, come ready, my lord. Deeply obliged, my lord.
Good.
My lord, I just missed to say one thing, my lord, very, very important. After preliminary degree has been set aside,
Come on the next day, I shall hear everything. Yes. Then
allow किया ना matter item number 1 1
My lord, we permitted to mention one matter, my lord. This civil revision, my lord. My lord, this matter, my lord, I have written a letter to the Secretary of the Honorable Chief Justice, my lord.
Yes.
My lord, it was assigned on 10th, my lord. That is on Tuesday, my lord. But it is not running in the list, my lord. That's why, my lord, I'm, my lord, deeply obliged. May the matter be, my lord, in the list, my
Anyway,
lord.
the moment the file comes, it will be listed.
My lord, the file has already come, my lord. That's
Then it will be listed.
my lord, deeply obliged.
Lordship, under compelling circumstance, may be permitted to mention one matter. Lordship, I have mentioned the matter yesterday. Your Lordship would remember.
No,
And
it
your
is
Lordship,
appearing in the list.
Lordship, it's appearing in the list, but Lordship, it's appearing under the heading motion, not under the specially fixed matter. Lordship, one kind indulgence, Lordship, if the matter can be taken up just before rising.
No. Can you wait till Monday?
Lordship, the date is
Not
fixed
Monday.
on Monday. Lordship, the date is fixed on Monday. Otherwise, I would not have
Item
come
number?
up 135, your Lordship. If it can be taken up just before rising.
Okay, at 3:15.
Deeply obliged.
Circuit bench. Clear, item number 1.
My lord, I appear on behalf of the respondent contemner, my lord.
My lord, I am for the petitioner, my lord.
Order, my lord. The respondent number 2, my lord, after hearing both the parties, my lord, passed an order, my lord, on 8th of August 2025, my lord. Your lordship may kindly go through the order, my lord's order, that
What was the order passed?
order passed, my
Lord,
lord.
the order was passed, my lord, to dispose of my representation in accordance with law. But the law says, my lord, if the petitioner has given the representation for separate title, if he is having a separate title, the law says, the rule says, shall be formed into a subdivision. There is a word to shall.
Order
And rejection of ground. If your honor will, lordship will see the rejection of ground that can be rectified by the authority themselves, not by the petitioner. They are asking us to do all these things, which can be done by only by the authority and the surveyor. What rectification they are asking, the surveyor is with them. Just after filing of this contempt application, just to avoid this
48.
thing, they have passed this order.
You see, page 40 is the order.
My
Which page of the petition?
My lord, 14 and 15, my lord.
Page 14 and 15.
My lord, this is the order of your lordship, my lord.
No. What is the order passed by the authority?
Lord, that is subsequent, my lord, because after filing of the contempt application, they have given with the order.
Okay. Yes, record an order.
But that order is not in accordance with the law.
For the petitioner and learned advocate for the opposite party contemner are present. It is submitted by the learned advocate for the opposite party contemner that necessary compliance have been made and the authority has passed a reasoned order. Stop. In the facts and circumstances, learned advocate for the contemner is granted opportunity to file an affidavit annexing the copy of the order which is passed.
My lord.
Let this matter, I'm keeping it after vacation.
My lord, my lord.
Let this matter appear on 27/10/2025.
My lord. Oblige, my lord.
Appellate side. Item number 1.
Yes, last occasion, the opposite party has filed the written notes of arguments. Are you ready with your written notes?
No, we already
Already filed. Yes, record an order. Learned advocates for the parties are present. Written notes of arguments filed be kept with the record. As hearing is concluded, the matter be treated as C.A.V.
Obliged, my lord. Mr. Ritendra Banerjee is appearing in this matter.
Yes, yes.
my lord.
Anyway, the name will be recorded.
File written objections, my lord, and substantially heard.
No. Written notes of arguments have been filed by both the parties. Yes.
So, I appear for the opposite party.
My lord, I appear on behalf of the petitioner. My lord, I am being led by Mr. Bhattacharya. My lord.
Let me see what is the order.
What are relating to the repairing?
Let me see the order.
My lord, only one thing, my lord, it can be, if it can be taken up on the next week, my lord.
No, I am adjourning it for the last occasions. Several days I am adjourning this
Several days
matter.
not, my lord, without giving any prior intimation, the matter came up, my lord.
The intimation has been served, thereafter matter has been issued.
No intimation was served, my lord.
Notice has been served.
No notice was served.
Yes.
But a notice has been served, thereafter matter.
Yes, record an order. I am keeping it on Monday. Let this.
I filed the written notes of argument.
Yes. Let this matter appear as a specially fixed matter on 16/9/2025. Yes, please come ready on that day.
Yes, my lord.
I will file my written notes of record an order. And
On
serve
that day I shall record.
Matter number 3.
I beg to appear for the petition in this matter. The revisional application, my lord, arises out of a judgment and order passed by the learned sessions judge dismissing my appeal from an order passed by the learned magistrate holding me, my lord, responsible for illegal construction under section 401A of the Kolkata Municipal Corporation Act.
Okay, you are filing.
So the offense is, my lord, I am found guilty of committing offense under section 401A of the Kolkata Municipal Corporation Act, and that is the
What's the
subject matter.
punishment?
Punishment, my lord, I am given 2 years of imprisonment and 50,000 my lord, fine. Now that is the entire subject matter which is, my lord, in issue before your lordship. Now my endeavor to show before your lordship would be one of the principal requirement by logic, by any stretch of imagination, by the statute, that I have to be found the person responsible for committing the offense. Lord, may I take your lordship gradually through the, I will not place today, it is in the motion stage. I will not trouble your lordship with this massive, my lord, this voluminous brief. I'll just place some paragraphs from the order of the London magistrate to show that I have not been, possibly my endeavor would be to show or establish that I have not been found as the person responsible. And my lord, to get there, if your lordship kindly allows me to place the relevant provision of law first.
Yes.
But may I place, my lord, section 400A? Your lordship has perhaps, my lord, gone through this a number of times, and I'll be referring to a very, my lord, very simple, my lord, content of this provision. Lord, may I am carrying, my lord, a soft copy. My lord, if your lordship allows me to read out, my lord, I do not have a hard copy, my lord, of the act. Your lordship kindly allows me to read out, my lord, section 400A of the Kolkata Municipal Corporation Act. My lord, it reads, it's first captioned as, my lord, 401A, construction of building in contravention of the provisions of the act or the rules made thereunder. Now the section starts, my lord, subsection 1. Notwithstanding anything contained in this act or the rules made thereunder or in any other law for the time being in force, comma, any person who being responsible by himself or by any other person on his behalf, comma, so constructs or attempts to so construct or conspires to so construct any new building or additional floor or floors of any building in contravention of the provisions of this act, comma, or the rules made thereunder. This is the first part, and then it goes on, as endangers or is likely to endanger human life or any property of the corporation whereupon the water supply, drainage, sewerage, or the road traffic is disrupted, or is likely to be disrupted, or is likely to cause fire hazard, shall be punishable with imprisonment of either description for a term which may extend to 5 years and also a fine which may extend to 50,000 rupees. Now, my lord, explanation. Person within quote shall include an owner, occupier, lessee, mortgagee, consultant, promoter or financer or a servant or agent of an owner, occupier, lessee, mortgage consultant of these different categories. So, my lord, therefore, my lord, if I can, my lord, interpret this section or rather try to understand this section, my lord, there has to be a person responsible. There has to be a construction which is beyond or in violation of the act or the rules. And that violation has to, my lord, be endangering human life or property. These are the three elements. If these three elements are found, then, my lord, perhaps I might be, if I am found guilty of committing of this, then perhaps the sentence will follow. So, my lord, person responsible is the first requirement, and person is also defined saying owner, occupier, lessee, mortgagee, consultant, promoter, and all these category of persons who are.
Okay, what are your grounds of challenge?
Now, if your lordship kindly takes up, my lord, yes. Now, if your lordship kindly comes to the petition and my lord kindly takes up, Lord, kindly, if your lordship kindly takes up, my lord, page 13, 1-3. That is the beginning of the learned magistrate's order. And my lord, I'll be referring to page 14. My lord, the accused details are given there. If your lordship kindly finds page 14.
Yes.
1-4.
Yes.
My lord, the serial number 1 of accused details, my lord, Mashrooq Ali. 2 is Noor Alam. These are the two petitioners before your lordship. 3 is Sheikh Ibrahim Bobby, my lord, one of the owners. And 4 is Shamshad Begum, another of the owner. So, my lord, the owners are there. And by this order, the owners have been acquitted. I have read out, my lord, the provision of provision in the section 400A.
What are the allegations against you?
Illegal construction, committing illegal.
Owners are acquitted. Owners
are acquitted. Owners are acquitted. I have been charged with, my lord, committing illegal construction, which, my lord, causes which endangers public safety, which causes, my lord, disruption to corporation, my lord, sewerage and water lines. That is the finding. Now, if your lordship may kindly take up the next page, page 15. I'm trying to place before your lordship the documents placed by the prosecution, my lord, for establishing their case. Your lordship kindly takes up page 15. I'll not take more than 5 minutes from here. Kindly takes up page 15. List of prosecution, defense, court exhibits. My lord, 1 is exhibit. Your lordship will kindly find stop work notice is there, service return, police intimation, day-to-day report, sketch plan, letter of complaint, complaint details, demand details, extract of SI, photographs, rough sketch map, notice under section 91, notice dated, another notice, report of joint inspection, notice under section 91, another, notice under section 41, photographs, rough sketch map. So, my lord, here your lordship will find it is conspicuous. My lord, I am being charged as promoters who have made construction. It is found that I am not the owner of the premises, and it is found that I don't reside there. I can show that from the judgment itself. And there is no, my lord, document here shown from the list of exhibits which connects me.
Is there any allegation that you are engaged by the owners?
That is the allegation, my lord. That is not here. That is not so expressly said in the judgment. It is only found that upon investigation, I have been found to be committing or continuing with the construction.
Actually, you were not implicated. You were not mentioned in the complaint.
Not mentioned. No, I was mentioned in the complaint. The complaint
you
was
as well as the other persons.
As well as the other persons. I was mentioned in the complaint. Or rather, it should be we were mentioned in the complaints because 2 petitioners are there before lordship.
Along with the owners.
Along with the owners. And the complaint was lodged by the engineer of the corporation. It's not a private complaint. Now, the documents which were shown before the learned magistrate were all, my lord, evidences or rather, my lord, inspection reports. Inspection reports, which, if your lordship is pleased to call for the records, will not show my involvement. My involvement has only come through, my lord, verbal evidence, through deposition.
Yes. Record. Learned advocate for the petitioner is present. Our learned advocate for the petitioner. This application is directed against order dated, judgment and order dated June 6, 2025, passed by learned additional sessions judge, first track court at Bichar Bhavan, City Sessions Court, Calcutta, in criminal appeal number 142 of 2024. Stop. Learned judge, by the judgment and order, dismissed the appeal filed by the petitioners and confirmed the order of conviction and sentence passed by the learned trial court in here case number 67 of 2021 passed by learned municipal magistrate second court Calcutta. The learned advocate for the petitioner draws attention to the judgment passed by the learned trial court and submits that although the petitioners are not involved in this case, but they have been wrongfully convicted. It is further submitted that the present petitioners were implicated with other co-accused persons, although they were not the owner of the premises where the alleged illegal construction is said to have taken place. Stop. It is also submitted that although the owners of the said building were acquitted, but the petitioners having no relation with the facts of the case are wrongfully convicted by the learned trial court and affirmed by the learned appeal court. Upon perusing the petition and the judgment passed and the materials on record, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week and affidavit of service be filed forthwith. Let this matter appear 1 week after vacation. Pending hearing of this application, there shall be a stay of the judgment and order dated 31/7/2024 in connection with GR case number 37 of 2021 passed by learned municipal magistrate second court Calcutta for a period of 3 weeks after vacation.
So
Ready.
And number 4.
Yes, are you appearing in person in this matter?
Yes, my lordship, I'm the person. So I'm appearing in person as I'm the victim person.
Yes, record an order.
So my lordship, I'm praying. Okay, you recorded the order.
The petitioner who is appearing in person is present. This application is filed with a prayer to direct expeditious disposal of complaint case number 1497 of 2022 under section 12 of the Protection of Women from Domestic Violence Act 2005, now pending before the Court of Learned Second Judicial Magistrate at Barashat, North 24 Parganas. It is the contention of the petitioner that this case is pending for a long period and the same may be disposed of expeditiously. upon considering the relief claimed, upon considering the relief prayed for, this court is of the view that no fruitful purpose will be served by keeping this petition pending and directing service of notice upon the opposite parties. Thus, this application is disposed with a request upon the learned Second Judicial Magistrate at Barashat North 24 Parganas to dispose of complaint case number 1497 of 2022 under section 12 of the Protection of Women from Domestic Violence Act 2005 within a period of 2 months from the next date fixed, without granting any unnecessary adjournment. Disposed.
My Lordship, I'm grateful. Thank you.
Yes, that's all.
And it's my first time.
Number 5.
Right.
In item number 5, I am for the petition. But this is a matter where interim maintenance has been granted to the opposite party, but the learned court did not ask for affidavit of assets. And that is a mandatory provision.
Well, which
Lordship, kindly
you are
come.
appearing for the petitioner husband.
Husband.
Yes.
Now, no affidavit of assets has been called for, and interim maintenance has been granted. I am only on that point. Only on that point. I have preferred a revision application before the learned district judge. District judge upheld the order. Page 40. Where the deposition, the petitioner, opposite party also said in examination in chief, in cross-exception, that he has not filed the affidavit of asset. And this has not at all been considered.
Oh, are you paying the maintenance at present?
Last month I have paid. But this order, I hope my Lord and Lordship will consider that this is not at all tenable. How the court has come into findings, this is the amount to be paid. Without taking a
No. Question is, the matter was decided upon hearing both the parties.
Only interim maintenance.
No, both the parties were heard. So it's not that.
No, it's not that
an
it
ex
has
parte
been
order.
heard ex parte. It's not that.
And it is upheld in appeal also.
Appeal also, that was allowed, confirmed. The lower court order has been confirmed. Without taking into consideration this part of the mandatory provision of.
So serve notice and come. Yes, record an order.
In the meantime, Lordship will kindly grant a stay of the operation of the order.
No, question is, you see, the order was passed long time back, probably in the year 2022.
No, execution case has been filed. That is the reason. They have filed the execution case.
When
And
is the
there is
date?
a restitution of.
No, you go on paying after, if you get a favorable order, you don't have to pay. How much you are paying now?
Now 5,000, what is the court has been directed, which are paid.
8,000, no, 8,000.
5,000.
Oh, that means the appeal court has reduced the amount.
No, 5,000 is the order.
8,000 has been. No, 8,000 was paid.
They have paid for 8,000. Now Lordship will find that miscellaneous appeal at 5,000 per month.
Yes, how much amount is due and payable till today?
35,000.
35,000
is due.
Due and payable.
Last month I paid 5,000.
So 30,000 is due and payable. Yes, record an order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. Learned advocate for the petitioner submits that the learned courts are in law in awarding maintenance, interim maintenance, without any direction to file affidavit of assets, which is contrary to provisions of law. Directing to file affidavit of assets upon perusing the order passed and the materials on record, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week, and affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Yes, are you paying the current maintenance?
Yes, my lord.
No, no, current, you
I
according
paid
to,
the current maintenance.
no,
I have
no,
paid it.
no, question, according to you, 30,000 is due and payable.
Due and payable.
Okay, without prejudice to the rights of the parties, the petitioner is directed to pay the opposite party rupees 15,000 upon making payment of rupees 15,000 and upon further payment of the monthly maintenance of rupees 4,000 per month, there shall be a stay of the order dated
30th June 2025.
No, stay of the order dated
page
21/3,
page
21/3.
Page 44, Lordship, can you find?
Page
44.
No, you see, this is the 21/3/2024. The order of interim maintenance was passed by the judicial magistrate.
That was confirmed by the learned appeal.
Yes.
That is at page 44.
So 21/3/2024.
Right, that is the actual order.
In the event the petitioner fails to pay rupees 4,000 per month within 10th of every English calendar month and rupees 15,000 which forthwith the order of stay will stand vacated and the opposite party will be entitled to execute the said order. This interim order will be for a period of 5 weeks after the puja vacation.
So this Lordship, can you clear, make it clear that 15,000 is the area.
15,000 area without prejudice and 4,000 go on paying on 10th day of every succeeding month.
I'm grateful to your Lordship.
Paragraph 6.
May it please your lordship. My lord, I have come before your lordship for quashing of the proceeding, including charge sheet number 572 of 2024 and 572A of 2024, both dated 31st December 2024, submitted in GR case number 3880 of 2024, arising out of Mogra PS case number 558 of 2024, dated 19/11/2024. My lord, from the date of occurrence, there's a delay of 23 days in filing of the complaint. And the delay is unconvincing.
Charge sheet is submitted.
My lord. My lord, I submit that it is not only an afterthought, it's concocted.
Yes, when is the date fixed for appearance before trial court?
April 2026.
Yes.
April 2026. And then at the juvenile court, already charge has been framed and
This person is not juvenile. These are the petitioners.
petitioner Titli Mondol is juvenile. She was during the time of occurrence, she was a minor.
Now age about 18 years.
My lord.
Oh, so far this petitioner number 3 is concerned, this court should not interfere at this stage.
As my lord pleases.
This is pending before Juvenile Justice Board.
My lord, Uttarpara.
Where?
Uttarpara.
Yes, record an order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. Learned advocate for the petitioner submits that the petitioners are falsely implicated in the instant case and the allegations made against the petitioners are not maintainable. It appears from the materials on record that the offending weapons could not be recovered and the injury report could not be collected. However, there are statements made by the witnesses. It is also submitted that petitioner number 3 was a juvenile at the time of commission of the offense. Stop. Upon perusing the petition and considering the materials on record, this court is of the view that with regard to the petitioner number 3, who was a juvenile at the time of the alleged incident, this court should not interfere when the matter is pending before the Juvenile Justice Board. Thus, this petition is dismissed with regard to the petitioner number 3. However, with regard to petitioner number 1 and 2, the case is admitted. Let notice be issued upon the opposite parties. Within 1 week, an affidavit of service be filed forthwith. Let this matter appear 1 week after vacation. Pending hearing of this application, there shall be a stay of further proceedings in connection with GR case number 3880 of 2024, now pending before learned Chief Judicial Magistrate HON'BLE for a period of 2 weeks from the date of reopening after vacation. It is, however, made clear that with regard to the matter pending before learned Principal Magistrate JJB Uttarpara, HON'BLE, this court does not interfere and the learned magistrate may proceed with the said case.
Deeply obliged, my lord.
Number 7. Number 8. Number 9.
Your Lordship, I'm appearing on behalf of the petitioner, item number 8. An analogous matter was fixed by Your Lordship yesterday itself on 15th of September, but this matter is appearing in the list today. I'm praying before Your Lordship to kindly keep the matter on 15th itself. Anima Bowdy, CRR. CRR 30.
Let this matter appear on 15/9/2025 as a specially fixed matter. 8 number, let this matter appear on 15/9/2025 as a specially fixed matter.
Grateful, Your Lordship.
9, 10,
10, Your Lordship, I'm praying for not today.
Not today.
11, 12, 13,
Malad,
Praying for a short passover, my lord.
item?
11.
Pass
My
over.
lord, item number 12, my lord, I am appearing for the petitioner, my lord.
Yes. Item 12.
My lord. Lord, this petitioner, my lord, preferred this revisional application, my lord, challenging an order dated 11/3/2025 passed by the learned magistrate, my lord. The flux of the case is, my lord, that proceedings initiated by the petitioner.
So what is this application for?
My lord, this is an application, my lord, for a revisional application for setting aside the order passed by the learned magistrate, my lord. In a nutshell, if I say, for lordship,
is
initially, my lord, an application under section 23 and 12 of the PWDV Act was preferred, my lord. My lord, kindly sees once the protection order initially which was granted, my lord.
Is this matter admitted and notice served upon the opposite parties?
No, my lord. Fresh, fresh, my lord. Fresh.
Yes.
My lord, page number 22, my lord, is an order passed by the learned magistrate, my lord.
Yes.
My lord, there the learned magistrate was pleased to dispose of an application under section 23, my lord, granting two reliefs to the petitioner. One, granting a monetary relief of a sum of rupees 3,000 per month, and another was the respondents were restrained from committing further acts of domestic violence on the petitioner, my lord. These were the two folds the orders were passed, my lord, granting reliefs.
Matter was disposed.
My lord, the interim application was disposed, my lord. Subsequently, my lord, the respondent opposite party husband preferred an application under section 29 challenging the monetary relief, my lord. That application was initially no stay was granted. My lord, the appeal running page number 24, my lord, under section 29. This was preferred before the learned district and sessions judge.
Yes.
Subsequently, my lord, the learned district and sessions judge were pleased not to interfere with the order and transferred the appeal before the learned additional district judge, 11th court, my lord.
Yes.
My lord, in the meantime, the opposite party respondent preferred a revisional application before the honorable court. My lord, the order of the honorable court is, my lord, on running page number 58. My lord, in running page number 58, my lord, 59 is the relevant portion where the honorable court did not interfere with the order and directed the additional district judge to dispose of the appeal under section 29 within 3 months. And my lord, for the meantime, the execution proceedings preferred by the petitioner wife to realize the arrear maintenance allowance, interim maintenance allowance by virtue of execution proceedings was stayed. Now, my lord, in the meantime, the respondents, they acted with cruelty and perpetrated further acts of domestic violence upon the petitioner wife. Pursuant to which, my lord, a separate proceedings were initiated before the learned magistrate, my lord, under section 223 of the BNSS and section 31 of the Protection of Women from Domestic Violence Act, my lord. Cognizance were taken, my lord. The accused persons, the respondents were asked to appear. They appeared, my lord, and preferred an application.
What is the order under challenge? Let me
My
see.
lord, the order under challenge is, my lord. Now, my lord, this is the backdrop of the case, my lord. Now I directly come. The order dated 11/3/2025, my lord. the last portion of the, my lord, the certified copy. Certified copy of the orders starts from just after, my lord, case number 58. 50 from 59, from 60, my lord, certified copy starts. And after eighth page from the certified copy, my lord, the order dated 11/3/2025. Now, my lord, the learned magistrate passes an order, my lord, that it appeared that instant complaint preferred by the Indrani Sadhuka so and so against her husband so and so under section 31 of the PWDV Act for violating the interim order under section 23 of the PWDV Act. Learned advocate for the accused husband submitted that AC so and so, while order dated 16/1/2024, this court was pleased to pass interim maintenance to the tune of rupees 3,000 per month in favor of the complainant wife. In the said order, no direction was given by the court concerned regarding protection and stay under section 17, 18 and 19 of the PWDV Act. My lord, this is, my lord, contrary to the order passed by the London magistrate, my lord.
Yes, record an order.
My lord, itself the London magistrate passed a protection order, my lord, restraining the respondents from committing any acts of domestic violence.
Learned advocate for the petitioner is present.
And here London magistrate is recorded.
Directed against order. This application is directed against order dated 11/3/2025, passed by the Learned Judicial Magistrate 8th Court, Alipur, South 24 Parganas, in AC 2085 of 2024 R-2085/2024. The learned magistrate, by the said order, dismissed the complaint case under section 226 of BNSS upon contested hearing and inquiry. Stop. On producing the order dated 11/3/2025 and considering the facts of the case, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week and affidavit of service be filed. Let this matter appear 2 weeks after vacation.
I'm grateful, my lord. I'm extremely grateful, my lord.
No. To the admission, just.
Under 12, 13.
Lordship, I am for the petitioner. I am led by Mr. Subhashish Chatterjee. He is engaged in another court.
Okay, not today.
Under 14,
Lord, grateful.
15, 16.
Lordship, item number 16, it's a expeditious disposal
Item
application.
16.
Lordship,
Let me see the record.
16.
Follow number ta din.
This is an application for expeditious disposal. Lordship, the petitioner before your Lordship is the accused person. The complaint was registered in the year 2019. Thereafter, charge sheet has already been filed in the year 2019. The total number of witnesses is 18, and out of which none of the witnesses have been examined.
When is the next date fixed?
Lordship, the next date before the trial court is on
Okay, total
6th
number
of
of witness 18.
18, Lordship.
No, what
Next
is the
date
next?
is 6th of March 2026. And till date, Lordship, no witness have been examined.
Yes, record an order. Learned advocate for the petitioner is present. Third learned advocate for the petitioner. This application is filed with a prayer for direction upon the learned Additional Chief Judicial Magistrate Koldani, District Noida, to dispose of expeditiously the GR case number 208 of 2023 arising out of Horinghata Police Station case number 179 of 2029, in which the present petitioner is an accused person. Learned advocate for the petitioner submits that although there are 18 witnesses, but till today, no evidence is complete with regard to any witness. Learned advocate submits that the direction for expeditious disposal of the case be passed. Upon perusing the petition and considering the facts of the case and the fact that the case is pending for trial, where the case is pending trial for a long period, no fruitful purpose will be served by keeping this application pending and directing service of notice upon the opposite party. Thus, this application is disposed with a request upon the learned Additional Chief Judicial Magistrate Koldani, District Noida, to dispose of GR case number 208 of 2023 arising out of Horinghata Police Station case number 179 of 2019, dated 12th May 2019, within a period of 8 months from the next date fixed, without granting any unnecessary adjournment.
Grateful, Lordship. Grateful.
Now 17.
Meet with your lordship. Expeditious trial number.
Let me see.
We like to copy the. Expeditious trial, my lord, I am for the de facto complainant, my lord, 302. 47 witnesses, my lord.
What is the present position?
My out of my lord 47, my lord 6 have been examined. Today was the date for recording of the evidence.
Okay, the accused persons are on bail.
Are on bail, my lord. They are taking time, different times before the court below.
When is the next date fixed?
Today was the last date. Next date has not been received as of now. Since today,
how many witnesses are examined?
6 witnesses have been examined.
No, you see, 22/5/2025, 17/7/2025 for evidence of CSW 14 and 15.
CSW, my lord, charge sheet witness number, not the prosecution witness.
Anyway, all witnesses may not be examined.
Yes, my lord.
So next date is
today was the last date. So my lord, next date we have not yet received. My lord knows better than me, my lord.
Yes, record an order. Yes. Yes. Learned advocate for the petitioner is present. Yes, what is your name?
Miss Anushwa Sinha.
Anushwa?
Sinha.
Yeah. MS Anushwa Sinha, who is the state advocate, is present in court. Let a copy be served upon MS Sinha.
It has been served.
Okay.
It has been served in the court.
This application is filed for a direction upon the learned trial court for expeditious disposal of the trial. Stop. The petitioner in the instant case is the de facto complainant of Kotwali PS case number 1119 of 2022, dated October 27, 2022, under section 302/34 of IPC. And now, pending before Court of Learned Additional Sessions Judge Fast Track Court 4, Krishnanagar, Nadia, being Sessions Case number 124 within bracket 03, 2023. Upon perusing the petition and upon hearing the learned advocates, this application is disposed with a request upon the learned Additional Sessions Judge, Fast Track Court 4, Krishnanagar, Nadia, to dispose of Sessions Trial number 4 within bracket April 2023, corresponding to Sessions Case number 124 within bracket 03, 2023, within a period of 6 months from the next date fixed.
Great fit, Your Lordship. Great fit, Your Lordship. Extremely good.
Disposed.
In item number 18, Lordship, I beg to appear on behalf of the petitioner, Lordship. In this matter, Lordship, the petitioner has been falsely implicated in a proceedings, Lordship, under the section 12 of the DV Act, Lordship. The proceeding initiated by a lady, Lordship, whether I am no way connected. So far, the victim, Lordship, the addition of party is concerned, I am not a proper party in this matter, Lordship. I am paying for expunging my name in the proceeding which has been initiated before the learned Judicial Magistrate, Lordship, Howrah. I have elaborately stated, Lordship, that whether I can be, so far I am not in a domestic relationship, Lordship, that my name has been added in this matter, and there is no such allegation in the petition itself, Lordship. I have annexed the petition, Lordship. Will not find any allegation against me or any relief they can shout against me, Lordship. But rather that, Lordship, they have implicated my name in this petition, Lordship. Lordship will come to page number 19 of the petition. Lordship will find the pair portion of the petition, Lordship. There is no relief has been sought against me, Lordship. To pass protection orders under section 18 of the PWD Act prohibiting the respondent.
9.
Lordship, I am the respondent number in the proceeding before the trial court, Lordship. I am the respondent number, Lordship. Only 4, Lordship, 4. That transfer from the page number 12.
What is your relationship with the petitioner?
Lordship, I am the so far the accused Pintu Pandit is concerned, Lordship. I am maternal uncle to this person. No, I am the husband of his aunt, Lordship. I even Lordship will find from the page number 12 itself, Lordship. On the very next page, Lordship, 13, he don't know my father's name. He has implemented it as a party in this matter.
When is the next date before the trial court?
Lordship.
Are you challenging the order or
challenging
the proceedings?
The cognizance. My name will be expunged, Lordship. The proceeding can be go. Only that petitioner has come, Lordship, before your Lordship. He is Subir Mukherjee. I am not in domestic relationship with that lady, Lordship. There is nothing prayed against me, Lordship. I cannot be a party.
No, allegations are there against you.
That only there is a mere allegation, Lordship, but I can assist your Lordship on that ground that they have made a 498 application. There is no allegation against me, Lordship. If it's so, if the mode of allegations, Lordship, that can also be it can be treated as an FIR, Lordship. So 498 case is there, Lordship. I can beseech your Lordship on that particular document, Lordship, that they have not implemented my name in the FIR. But when they have filed this domestic violence application, Lordship, they have inserted my name.
Where is that order? Let me see.
Lordship will find from
order
that is in certified copy, Lordship. Lordship will find from the very, it is not paginated, Lordship. Lordship will find from the very next page of the certified copy, Lordship. That is the order passed on 10th January 2025. Shrimati Barsha Pandit Chakraborty files a petition under 12, and that has been subsequently transferred before the 4th court, Howrah, for disposal. Judicial Magistrate, learned Judicial Magistrate.
Question, you see, this is not purely a criminal case. This is one type of civil. So
it's a quasi civil procedure, Your Lordship. The proceeding should be
some restraint order and some maintenance order.
Yes, Your Lordship. So why I am in
prima facie, you see, prima facie 482 jurisdiction should not be invoked.
Lordship.
Yes, record an order. Learned
I will
advocate.
come and satisfy to your lordship whether it
You
can
see,
be
it
invoked or
should,
not.
you should satisfy before the court below,
Lordship.
because you see, had it been any complaint or criminal case, it could have been considered. But
Lordship, so
these
far the-
cases are not purely criminal
Lordship,
cases.
let me come back, lordship, after service, lordship. I will satisfy your lordship.
Whatever
Otherwise,
it
lordship.
is, you see.
Yes, your lordship. I will satisfy on that ground whether 482
Okay,
can
learned
be
advocate for the
lordship
petitioner is
invoke or not,
present.
lordship.
Learned advocate for the petitioner. The petitioner is being aggrieved by his implication in criminal case number 23 of 2025, pending before learned Chief Judicial Magistrate Howrah,
Presently pending before the learned judicial magistrate, 4th court, lordship.
Howrah, and now transferred to the court of learned Judicial Magistrate 4th Court at Howrah under section 18/19/20/22/23 of Protection of Women from Domestic Violence Act 2005. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties and affidavit of service be filed. Let this matter appear 2 weeks after vacation. When is the case before the learned trial?
The last date was 14/8/2025, lordship. Maybe any day on November, lordship, I will get the next date, lordship. So far, the order is transferred from the record, lordship. Its last date was 14th August.
As this matter is sub judice before this court, the petitioner is granted liberty to pray for adjournment before the learned magistrate, which may be considered.
Lordship. Grateful to your lordship.
Item 19, I'm praying for a day accommodation, your lordship.
Not today.
20.
I am for the petitioner. My lord, I have come up for quashing of a criminal case under section 341, 323, 325, 506 of the Indian Penal Code. My lord, the opposite party number 2 is married to the sister of the petitioner. The petitioner's sister is the wife of the opposite party number 2. My lord, there was a matrimonial discord. She was beaten.
Petitioner number 2 is the
husband. Is the opposite party number 2 is
okay. Opposite party number 2 is
Sujit Sarkar,
husband of the sister of the petitioner.
Now there was a matrimonial discord, and she was beaten and driven out of her matrimonial house.
Yes.
They were constantly in drive to mitigate the situation. But this opposite party number 2 was asking for rupees 25,000, 30,000, pressurizing them. On the fateful day, what happened? This opposite party number 2 and a friend of his came to the spot, house of the opposite of this petitioner, in order to threaten his sister. But finding sister not in the home, he got the petitioner and then started quarreling with him and threatening him. There was a scuffle, and thereafter he left. I have annexed the 161 statements. The witnesses who were with him and present on the spot, everyone says that he came to the spot. It is not that the petitioner has gone to assault him. He was near his house. He came to the spot with a friend, quarreled with him, and then there was a gentle push. No offense of 325 or 341 or 323. Kindly comes to the 161 statements at page 12, 11 of my petition.
Any injury report collected?
No, we have not been served with. Charge sheet was submitted. We have not been served with any injury report.
No, question is it reflected in the charge sheet that injury report?
No, it is not. In the police report, it is not. In the brief facts of the police report, that is the police report.
Yes,
actually.
which page you are relying?
My lord, I am relying on 161 statements, page 15.
Yes.
My lord, may I read it? আপনাকে আপনার জিজ্ঞাসায় জানাচ্ছি যে আজ বলিতেছি যে গত ইংরেজির 15/9/2019 তারিখে আনুমানিক দুপুর 12টা নাগাদ আমি the specs my lord, I use my specs. আমি এটা কি আছে? হাজির at the last minute will kindly come and see last two lines. Witness number page 15 my lord. Page 16 also same, he was also on the spot. এবং ওদের কথা আমি তারপরে ধাক্কাধাক্কি হয়, ধাক্কাধাক্কি দেয়, he came to the spot. দেখতে পাচ্ছি না স্পেক্স এর জন্য। Page 16 my lord.
Is there any counter case against this
No.
this de facto complainant by his wife or whatever?
No,
it
no,
is?
no. Huh?
Counter
আছে? Oh yes, madam, there is a counter case.
By the wife of this person, opposite party number 2. Opposite party number 2 is the brother-in-law of the petitioner.
Yes, brother-in-law of the petitioner. কোথায় counter case? সেটা আগে করেছিল। এই ইনসিডেন্টে তো করেনি। Well, that was before the case was done, not due to this incident. There is no counter case. সেটা কেন? কি কেসটা কি? কি কনফার্মেশন? সেটা জানতে হবে তো। Separation of fact.
Yes, record and order. Learned advocate for the petitioner is present. At learned advocate for the petitioner. This application was sought for quashing of proceedings, being GR case number 2376 of 2019. Now pending before learned additional chief judicial magistrate at Bonga, North 24 Parganas, in connection with Calcutta PS case number 717 of 2019, dated 18/9/2019. Stop. Learned advocate for the petitioner draws attention to the charge sheet and statement of the witnesses and submits that the allegations made against the petitioner are not maintainable. This further submitted that the petitioner number 2, that the opposite party number 2 is the de facto complainant and husband of the sister of the petitioner. Learned advocate also submits that the materials on record that it does not justify further proceedings against the petitioner. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let this matter appear 2 weeks after vacation. Pending hearing of this application, there shall be a stay of further proceedings of GR case number 2376 of 2019 in connection with Calcutta Police Station case number 717 of 2019, dated 18/9/2019, for a period of 3 weeks after vacation. Please.
One.
My lord, I'm praying for a day's accommodation, my lord.
Not today.
Great.
22. It's my application, my lord. My lord, a case has been registered in the year 2023 after a raid by the police authorities of Asansol. My lord, they found Mr. Ranjit Kumar and some of the persons fled away. My lord, on a tip that the cyber crime offences are being committed in a room, in a computer, through computers, and phishing mails have been sent. Ranjit Kumar gets arrested. Thereafter, he takes a name of Rizwan, and my lord, the FIR has been started. Kindly sees there is no name. My name is Savita Nandan. It's only one statement of Mr. Ranjit Kumar makes me that
accused person.
I'm the accused person.
No, the statement
made by the accused person number 1.
So on his statement, this
On
person
his statement, my client has been apprehended. Now, what happens, my name is in the charge sheet, not in the FIR. Subsequently, only my name has been involved. That my account, I used to pay him, or Ranjit Kumar, the accused number 1, used to pay him money. I used to give him in cash. Now, the sections, what happens, the charges leveled against my client is 420/406. None of the charges fulfills of the criteria, ingredients of the sections does not fulfill with the action of my client. I was a person, I have been told my friend that I will give you some money, you give me in cash. He uses my account, some of the transactions rather. Kindly see in the chart sheet, page number 25. The brief facts does not makes any whisper of my name.
That is page?
Page 25. That's the chart sheet. The facts of the case in the brief that on 15th June 2023 received a typed complaint from the Sushant Pal, the ASI of Police, Asansol Cyber PS, to the effect that 15/6/2023 at about 1:15 hours, ASI received a source information that 2 to 3 persons are doing cyber crimes inside a room near Ushagram, Navapolli under Asansol PS. Accordingly, he informed that the matter to a superior officer, and after getting permission from superior officer, he along with constables Milan Chandru such and such left for Ushagram to work out the information. After reaching there, with the help of his source, who identified the room, where police team noticed that through window that 3 source who identified in the room where the police team noticed that 3 persons were doing something on laptop and mobiles. Then the police team entered into the room to hold raid. On seeing the police team, 2 persons were fled away from the room and from the backside of the room. And the police team are able to apprehend 1 person along with the laptop and mobile phone. On asked and identified himself as noted above. Police team started interrogation, but he misguided the police team. After searching the laptop and mobile phone, the police team again interrogated him thoroughly and at last confessed his guilt and disclosed that 7 to 8 months ago, he met with one Rizwan of Kolkata on Facebook platform, and this person is the Ranjit Kumar. The Rizwan sent him about 10,000 to 12,000 email IDs.
So this is what is the name of this petitioner?
Savita Nandan.
So he was not arrested from the spot?
No, my lord. I was not in the spot.
How many accused persons? Total 2.
Total 2 accused persons. Now
he was not arrested from the spot.
Yes.
And during his arrest, anything recovery?
No.
Any recovery?
Nothing recovery. Not my mobile, not my laptop, nothing. It's only a single statement of my lord. I will show in the page number. Page number 20. Rather 21. There is 161 statement which is of no value, but still the 161 statement, and the last line he says the entire facts that he says that Rizwan used to give him tips and everything. এছাড়াও আপনাকে জানাইতেছি যে সবিতা নন্দন নামক একজনের থেকে আমার পেটিএম ওয়ালেটে টাকা আমার কাছে আসতো। This is the single line.
So this person is on bail now.
Yes, he is on bail. Now, my lord, the charges which has been levied, my lord, if I portray, my lord, kindly, my lord, if I try to explain, my lord, the charges are 420, 419, 406. 419 who were cheats by personation. I am not. Now 420 says who were cheats thereby dishonestly induces. I have never done. Rather, he says that he used to give me money. Now 406, now, whoever commits criminal breach of trust, such and such. There has to be something in my possession, and I have done something wrong. Now 467, who have forges document. There is no allegation that I forged any document.
468 is also mentioned.
468. Yes, ma'am. 468. Even 468. No, forgery for purpose of cheating.
Yes. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner peruse the petition file and materials on record. Learned advocate for the petitioner submits that the petitioner was not named in the complaint and subsequently implicated on the basis of the statement of co-accused person. Stop. Learned advocate further submits that save and accept the statement of the co-accused persons, there are no other materials to implicate the petitioner in the instant case. It is also submitted that the allegations made does not attract section 419, 420, 406, 467 and 468 of the Indian Penal Code. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties and affidavit of service be filed. Let this matter appear 2 weeks after vacation. Pending hearing of this application, let there be a stay of further proceedings of here case number 1676 of 2023 arising out of Asansol cyber crime. Yes, case number 13 of 2023 dated 15/6/2023 pending before learned Chief Judicial Magistrate Paschim Bardhaman for a period of 3 weeks after the vacation. Yes, call the fixed matter,
Grateful,
mentioned matter. No, for the time being, you see, in segregated way, the case cannot proceed. Within a particular time, this application has to be decided.
Chief's correction, has the petitioner received supply of copies? Otherwise, he is.
Yes.
Oh, charge sheet.
I have filed. I have filed the charge sheet.
Charge sheet is something else, and he will be able to go through all the materials only when the stage of supply.
Anyway, okay, let's record one other thing. Let the case diary be produced on the next date fixed.
Grateful.
Matter item number 135.
My lord, I am for the petitioner. ये ছিল this is my application. This is under section 498 406 34. Whereby charge sheet has been submitted under section 498 34. Petitioners are the husband, mother-in-law, sister-in-law, and husband of sister-in-law. Your lordship would kindly straight away come to page number 30.
Yes.
First paragraph, second paragraph. However, yet again, my husband proved himself to be untrustworthy. He has stopped sending me monthly expenses and has not returned the money that he had taken from me.
He has once again started threatening me and torturing me mentally. Recently, he has stopped paying me my monthly expenditure, has taken away my car and driver as well, and have asked me to vacate the flat within a day or two. He has threatened me to the extent that if I fail to vacate the premises and go back to him, he will come there and beat me up like the previous occasion. Next paragraph. Thus, I am presently lying in a pathetic condition, all alone with insufficient funds to maintain myself, having to depend upon my parents and family members due to the tremendous mental and physical harassment and torture that I have faced at the hand of my husband and with the active support of my mother-in-law, sister-in-law, and brother-in-law. My husband has tortured me mentally by abusing me repeatedly, using foul and filthy languages, by flaunting his extramarital relationship. He has also physically assaulted me on several occasions. This is the allegation. Your Lordship would kindly come to page number, the charge sheet, second page of the charge sheet, that is certified copy. Second last page of the brief, my lord.
Yes. Yes.
At the bottom, my lord. During investigation, visited the PO, examined the several witnesses and recorded the statements under section so and so of CRPC. During investigation, had been to the resident of the complainant at so and so, where she used to live with her husband, to serve the notice under section 91 CRPC, but the complainant refused to receive it and stated that she will withdraw the case. Then undersigned tried severally to serve the notice under section 91 CRPC to the de facto complainant, Viva Khanna, but she refused to take the notice on every occasion. Next page, third paragraph. During investigation, served notice under section 91 of CRPC, sent to the complainant, but she did not receive any of those, which and was not cooperating with the investigation agency. As such, no document pertaining to her marriage could be seized. She did not accompany the undersigned for recovery of Stridhan article. I leave it to your lordship whether the allegation made in the FIR as well as the conduct which has been recorded in the charge sheet qualifies the ingredients of 498A or not. I leave it to your lordship.
498A, 34 and 3 and 4 of DP Act.
Yes.
Yes, record and order. Learned advocate for the petitioner is present. Had learned advocate for the petitioner. This application is filed with a prayer for quashing of PGR 797 of 2020 arising out of New Alipur PS case number 53 of 2020 dated 7/3/2020. Now pending before learned judicial magistrate 6th Court, Alipur, South 24 Parganas. Learned advocate for the petitioner draws attention to the petition of complaint and also to the charge sheet and submits that from the statements made in the charge sheet that the de facto complainant did not accompany the undersigned for the recovery of Stridhan articles, and she also stated that she will withdraw the case and was not cooperating with the investigating agency. And the allegation made in the last but one paragraph of the complaint will go to show that the allegations under section 498 capital A stroke 34 read with section 3 and 4 of the DP Act are not maintainable. Upon perusing the complaint and the charge sheet and upon hearing the learned advocates, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week. An affidavit of service be filed. Let this matter appear 2 weeks of application. Pending hearing of this application, there shall be stay of further proceedings of CGR 397 of 2020. Now, pending before learned judicial magistrate 6th Court, Alipur, South 24 Parganas, for a period of 3 weeks after vacation.
Deeply, please. Deeply.
হয়ে গেছে তো?